India. Pkd Nambiar is a political analyst. Mr. Nambiar, would you say that maturity of various communities, maturity of various litigants will now be put to test?
I would say since morning, I've been on another channels also hearing different people. Today is a day, I think it's a historic day. Rather than talking about what about the review and etc., I would say it's a historic day both as a social justice for this particular country. Also, most importantly, the kind of maturity in which every political leadership to communities have been so far commenting on this particular thing is highly appreciable. I think we have moved as a nation to great extent. This is a case which is over and out. Justice is being delivered. I would even say, as a Hindu community, is really looking forward for such kind of an. This is an injustice which has been happened for the Hindu community over the last so many centuries. Finally, the Hindu community today got the real justice. Okay. Let us appreciate the five judges bench has given this decision.
I don't think Vijay Shankar Pandey, the decision that has been taken by Sunni Waqf Board, I would say it's about now moving ahead rather than looking at the egos of people within these bodies.
See, it's up to the litigants to decide about the future course of action. If Sunni Waqf Board has taken a decision as a body, because the problem with Sunni Waqf Board is that earlier also, when the hearing in the Supreme Court was going on finally at the final stage, a statement came from the chairman of the Sunni Waqf Board stating that they are going to withdraw the claim from the,
that's right.
But soon thereafter, the board statement came, the secretary of the board said that we don't agree with this, and he is speaking in his individual capacity. So we should find out very clearly whether he is expressing the view of the board or not. In case he is expressing the view of the board, then it is a final. As far as Sunni Waqf Board is concerned, do not want to move further in this case. But there are other litigant parties also from the Muslim side. It is up to them to whether to approach the Supreme Court for review of the judgment or not. So it's a discussion of them.
Yes, as a litigant, they are in all right to
they have the right to it is for them to decide what course of action they want to follow in future.
Yes, but the point that I'm trying to make here is that Zafar Yab Jilani spoke. Did he speak too soon? Because it's a 1045-page judgment, there are several aspects that are mentioned here about the ownership of the land, about what ASI's findings are, about faith, the question of faith, namaz and Hindu prayers, and all those details are part of the judgment. Did he speak too soon?
It seems that, while the Honorable Chief Justice of the Supreme Court was pronouncing the judgment, he clearly said initially that Shia Waqf Board goes out, then Nirmohi Akhada goes out.
Yes.
The two parties were left.
That's right.
So whatever discussion, whatever points he made, quickly you can grasp what exactly was the line that the Supreme Court took. I think on the basis of that he must have got taken the initial thoughts that there is a scope for review of the case. Basically review is a very limited scope. So you can't reopen the case. It's basically...
And it's a unanimous judgment.
It's a unanimous judgment. You have to, bring before the Honorable Supreme Court the fact that there is a material apparent on the face of the record. Then only you can go for review. So it must have been, the wisdom of Mr. Jilani to come to a conclusion there is a material defect on the face of the record. That's why he initially said that. Honestly speaking, yes, but unless you read the 1000 pages or pages, you won't be able to appreciate what exactly were the grounds on the basis of which Supreme Court arrived at that decision. I tell you, the 2010 High Court order of Allahabad adjudication, it was also 1000+ pages. And so many nuances were there. Unless you read it and go in details, you won't be able to appreciate why they did what they did. Similarly, I will request all the parties to really go through the fine print and the analysis of the Honorable Supreme Court. Then you are well within your rights to take the matter further, apply for review of the judgment. But on the basis of hearsays and some points here and there, one should not jump to the conclusion. You are absolutely right. But 2-3 points are there, as Utkarsh mentioned. The Honorable Supreme Court has taken 2-3 very important decisions in this matter. You know, as he mentioned, none of the two parties were able to prove their right on the piece of land. This exactly was the decision which Honorable High Court arrived at in 2010. So what Supreme Court did was just balance the the weight in favor of one party to another. Conclusively, as he mentioned, nothing proved. None of the parties could prove, but they weighed which party is heavier as far as the overall evidence is concerned. Accordingly, they came to the